Again, I'm going to point you all to the meeting materials to take a deep dive into everyone's backgrounds. Most people on the panel are from firms or organizations you've heard of. So I'm going to start with Kate, who is from Sanford Heisler. I'm going to move on to Joy from Jackson Lewis. Katie from Aptmetrics, a consulting firm. And then finally, our next commentator, Professor Cherry from St. John's University Law School. And with that, I'll turn it over. Thank you.
All right. Thanks, everyone. And I really appreciate the lead-in that we had from the last panel, because we're going to be talking in much more detail about pay equity on this panel. So you heard a little bit about our speakers. I'm going to introduce them first. Then what we'll do is I'll give a very high-level overview of some of the issues around pay transparency, picking up, I think, where Dr. Zhang left off in the last panel. And then we've got a hypothetical to go over and for the panelists to talk about, and we hope that everyone will also be engaged in asking questions or offering thoughts on this problem that presents some of the pay equity issues, I think, in very interesting detail, and some of the aspects of what goes into analyzing some of these cases. So I'm going to start with Katie, who's sitting next to me, and she's a vice president at Aptmetrics. She leads a solution delivery team with a special focus in litigation support. She provides consulting services in the area of litigation support, assessment, development, and validation, job analysis, and competency modeling to Fortune 100 clients across industries. And she has worked as an expert witness to counsel. She's provided substantial support in other consulting and settlement work, expert work in employment discrimination cases for both defendants and for plaintiffs. Then I'm going to turn to Joy Chin, who joins us today. And to give you a little bit of her background, she's a principal in the Long Island office of Jackson Lewis. And she served as a member of the firm's board of directors. She's co-leader of the firm's affirmative action group and government contract compliance group, and co-leader of the firm's pay equity group. She has 25 years of experience helping employers navigate EEO and affirmative action regulations, and she works regularly with corporate counsel and HR executives to develop practical approaches to EEO and affirmative action compliance. And she's successfully defended employers in litigation at various EEOC complaint investigations, including glass ceiling audits and claims of systemic discrimination in pay, hiring, promotion, and termination. So we have another perspective. And then I'm going to introduce Kate Meeting. And she is the firm administrative partner and co-chair of the firm's discrimination and harassment practice group at Sanford Heisler Sharp LLP. She's also co-chair of the firm's executive representation practice group. She has taught and written on a broad range of topics that include gender and pregnancy discrimination, gender pay gaps in professional services firms, maternal walls, professional development and career advancement, bias in the legal profession, and diversity and inclusion, among many other topics. So we have a terrific panel here, again, that covers, I think, many different perspectives that we can bring to this topic of pay equity and pay transparency. So just to give a very high-level overview, because I know those in this room have been thinking, many of you have been thinking about these issues for some time. But if we think about going back into the history and the longstanding roots of pay discrimination and women's underpayment, right? This was conceived of, I think, in many regards, both in the 1960s, but also before then, as a human rights issue. So pay equity being seen as something extremely important if we're thinking about advancing women's rights and economic rights. And as Dr. Zhang mentioned in the last presentation, if we look at what the statistics are currently, so in 2023, right, this is the source is the Department of Labor, right? This is where I got this from. And we can see that this gap is persisting. And so if I put it in another graph, or to look at this in another way, we can see that this also has an intersectional element that Dr. Sang mentioned as well. So if we think about where women of different groups are compared to men, and then we add in factors that include race, we end up seeing that women of color are still left until 2451 or 2369 in order to gain pay equity at the rate that we've been going currently. So that's not a great story to tell, right? That's something that deserves our significant attention. And I could reproduce graphs here that also say similar things if we take into account intersectional analysis, thinking about factors like disability and thinking about factors like LGBT status. And we could think about this as really being connected to two different aspects, and I'll just be very quick on this, but we could think about this in terms of horizontal segregation or horizontal questions about where women have particular jobs, but also think about this in terms of supervisory responsibility, who is getting promoted, and then the pay effects that that ends up having. So when I describe all of this and say we need to do better, we need to think about what we can do, there are real challenges, I think, that exist to trying to use the law to address some of these concerns. And I think some of this is that many of the issues are sector-wide, but the laws are focusing on individual employers. And if we think about it, directly identifying specific practices can be hard. There are limitations sometimes on what can be done in terms of class actions and who can be included in them. I also think there's another concern here, which is that a lot of this, if we think about the causes of this, many of this could be distilled down to stereotypes about people and the kinds of work that they do or their jobs. And the most recent example, or something that's just been in the news over the weekend, I think, came up with the graduation speech that we heard from the Kansas City Chiefs kicker, right, who was extolling the virtues of having women at home and that that's their most important vocation. So, right, so he said it out loud, but the question is, right, is this unconscious bias also happening even when it's not being said out loud? And we can think about traditions, historical practices, maybe as part of the gender-specific or gender-dominated fields. And then also family responsibility discrimination, which is something that is also has a correlation with gender, is not gender, but is perhaps related, right, if we think about the factors that are related to this persistent pay gap. And so, again, there could be more causes than we think about, right? What are the opportunities that are there? If we think about women's choices, we'll put that in quotes, or to choose a particular profession, some of that may be constrained. Some of that may be constrained by factors such as wishing to not have harassment at work. There are other questions, though, too, thinking about questions or wondering why women don't ask, right? Why are they not negotiating? And relying on salary history, which in some states there's been a move to ban that kind of question or ban that kind of analysis. So where do we go, or what are some proposed solutions? I do think looking at this this is large organizations, and what have they been doing? And many of them have been conducting analyses, trying to figure out what they can do in order to try to fix this. And that might include more than just gender, right? That might include analysis of other factors that are leading to discrepancies or problems with equality and pay. There can be, after a study like that, there can also be various techniques to try to remediate that problem, trying to figure out which is best for the organization, and then trying to increase the amount of pay transparencies at these organizations. So there's change even within large organizations that are engaging in self-reflection, self-analysis in order to get to that point. And as far as pay transparency laws, right, we can see that it was mentioned, states are in the process of passing this. The states that are in blue are the states that have passed a transparency law. There are 10 of those currently. And then the ones that are in orange are considering it. But there are also municipalities within states across the country that have also been implementing within their municipal area pay transparency laws. But there's some areas and aspects of complexity and tension that I know our panel is going to be talking about in this hypothetical that we're going to discuss. And some of this is how we try to define what equal pay is. So we could think about this in some ways. We could think about equal pay for equal work, but then we could also think about equal pay for comparable work. And then we also have to ask questions, I think, about who is similarly situated. And again, Dr. Sang gave us a very good lead into this. Are we looking just at a very narrow category? How do we define the categories? Is it broadly? Is it narrowly? And that may make a difference in terms of thinking about some of the issues that come up. So, all right, we're going to talk here about a hypothetical, and this is going to be the fun part, right? Discussing with our experts really what some of the issues here are. So this is a hypothetical about a company, and it's Alan Muskrat, who's a businessman and investor. He purchased a social networking site called Chitter. Eager to make the company his own and streamline the organization, he renamed the company X and laid off most of his workforce. Some of this should sound familiar, right? He brought in Al Guru as the chief technology officer to lead X's elite group of software engineer analytics leads. These are the SEALs. To develop and work on special, sophisticated, high-tech projects. To ensure that Al would accept the position, Alan set Al's salary above the market rate for a CTO position. Alan and Al soon realized that one of the SEALs who had been let go, Samantha, Sam, Alt-Deleteman, was critical to ongoing projects. They contacted Sam and offered to reinstate her at the salary she was being paid when she was let go just a month ago. Sam, snapping out of her defiance and anger over being let go, accepted the offer. To expand X's capabilities, Alan also needed software engineers to update X's platform, develop and work on new projects. He brought in Sherlane Inberg as X's chief data officer, CDO. Sherlane, formerly a team lead software at Gaggle, was to oversee X's new engineering research and development squad, the Nerds. Alan had an idea of Sherlane's compensation as a team lead at Gaggle and knew she was ambitious. She would not pass up an opportunity to join X. So Alan set Sherlane's salary slightly below the market rate for a CDO position. Alan and Sherlane realized the downsized staff were working at capacity. Alan agreed they could recruit externally for the SEAL and Nerd teams. In accordance with state and local pay transparency laws, X dutifully posted the expected salary ranges for these positions. The salary range for the SEAL team positions was higher than that of the range for the Nerds positions. To streamline the recruiting process, X posted one advertisement for a software engineer position and included a salary range that used the lower end of the Nerds position as the minimum and the highest end, the higher end of the SEALs team position as the maximum. After several individuals were hired for the SEALs team and the Nerds, X's compensation team decides to conduct a pay equity analysis. They retained an outside consultant, the tortured numbers department, to conduct the analysis. To protect the analysis, under the cloak of attorney-client privilege, they copy X's in-house general counsel on all communications. Sam subsequently learns that the posted salary range for software engineers was higher than her salary. She also learns that former Chitter software engineers who were brought back at their former salaries generally were paid less than the new hires. Sherlane realizes how much more Al Guru was earning than she was. They each file a complaint on their own behalf and the Jane Does to be determined, alleging systemic pay discrimination based on sex in violation of the Equal Pay Act and Title VII. So a lot of facts, but a lot to think about. And so with that, I'm going to turn it over to our panelists' initial thoughts.
Sure, yeah. There's a lot to unpack here. And I think looking in particular at Sam and what Sam is going to be looking at and looking that she's and looking for her pay claims, I, as someone who may represent someone like Sam, is going to want to argue for a broad range of comparators. And so I'm going to look at the fact that the company did one job posting for both positions and assert that that is evidence, that's an indication that they were all doing the same position, both the SEAL team and the NERDS team. And I'm going to want to ask Sam a lot more questions about that. I'm going to want to ask her, when people are out on vacation or on leave, is the work fungible? Is it interchangeable? Are they filling in for one another? When the company needs something done, are they saying who's available and pulling from both divisions, or are they just looking at one division or another? So those are some initial thoughts, but I know we're going to dive into this great hypothetical a lot more later.
So if I am representing the employer, X, I would, when we were working on this, I actually found it interesting that Kate and I would actually look at the same factors. We just look at it in a different way. And I think in addition to some of the things that Kate mentioned, I would also look to see whether the employer had national policies and practices in terms of hiring, recruiting, to evaluate whether the plaintiffs would look to make a case that it was a national overarching decision impacting, or whether it was isolated to a particular facility or a location. I think it's, I would also look to see whether they had done an analysis proactively. I'm not saying I would necessarily use it, and I think we're going to talk about that shortly, but to talk to them about what their pay system consists of and what their pay practices truly are. I would tell you that many employers have not yet had a chance to look at this. A lot of them are turning to it and focusing, keeping in line with the theme of this conference, with the challenges and opportunities. I think the challenge has been all of these new laws that are popping up, right? It is an opportunity for employers to focus on their pay systems and their pay structures and how they're paying people. And it's not just the amount of compensation, right? But who are you comparing, right? Who are you lumping together and paying in a similar fashion? And that's really what I would focus on initially, at least in investigating the claims. In responding to a plaintiff's claims, I would probably also start with their groupings and what they're alleging.
Yeah, and hi everyone, I'm Katie. I'm an industrial psychologist, so representing a slightly different viewpoint here. I think the most critical piece from my perspective on the IO side is really understanding those job groupings. So agree with Kate that the singular posting for the NERDS and SEALs might be a place to start. However, I would really want to take a deeper dive with the company, or to the extent that I could into their materials. Is it really one job description? Why did they post these together? Really to understand, are those jobs appropriately grouped together? So I think that analyzing the jobs and understanding the work is really a key first step in this hypothetical.
And if I may, just to follow up on something Joy was saying, that she would look at what the plaintiff was saying or what the employee was saying would be the appropriate comparators. And I think this just goes back to another reason why pay transparency can be really important, right? My clients' employees often have no idea how much other people are making or what their ranges are. And now that the ranges are being posted, they are able to say things like, look, the range is 100 to 150, and even though I have more experience than almost everyone in the role, and I've been training people who come into the role, I am way closer to that 100, the low end of the range, than I am to the high end of the range. And that is going to cause her to start asking some questions and being able to put together some of that information that is now being required in those pleading standards.
Yeah, I was really excited to hear some of the initial findings from the last panel on the impact of those laws, seeing that they are closing the gap a little bit at least. Maybe some unintended consequences as well, but a good start.
All right, so do we want to talk a little bit more about the comparators and who would be similarly situated? Maybe starting with Sam?
Sure, yeah. So Sam is within the SEALs group. She's not, so she was reporting up to Al, and in the other division, Charlene is at the head, just so I'm clear on the names here. So Sam is going to want to argue for a broad range of comparators. She's going to want to look at everyone in the SEALs team and talk about the kind of work that they do. As well as maybe pulling in some of the nerds, because sounds like she's underpaid relative to both of them, to people in both groups. She's going to look at this within Title VII. She's going to want to say that they're similarly situated, they're doing similar work. And for Equal Pay Act context, in that context, she's going to want to say that they have the same skill, jobs require the same skill, effort, and responsibility. She's doing substantially equal work. So that's going to get into that kind of fungibility questions that I talked about earlier, the one job posting, that one salary range that was posted. She's going to want to look at who is being trained. Are they all being trained together on the same projects and the same things, or are there segregated trainings? Are they all being evaluated using the same metrics and the same criteria? And so she's going to want to look at the performance evaluations and look at what is being required of the job in order to make the case that she can avail herself of that broader range of comparators.
I agree. I would look at the same factors, but hoping to find, some differences among those factors to help distinguish, right, the different positions. I would look to see whether some of the individuals, what types of projects they were working on, whether there was a more specific experience, right, or a higher level of experience for the projects that they were working on. But keeping in mind that the challenge here with these cases is that the standards are different, or they're from Equal Pay Act cases and Title VII, and then there's inconsistency, right, in the case law about how those standards are being applied, right, under either the Equal Pay Act or even under Title VII. So there are some, I think it's the Ninth Circuit that has said that it's really a broader group, right, that you can't hone in on very specific things. Other circuits have said, no, it's just a broad group. An attorney is an attorney is an attorney, right, in one case, saying that we all do the same things, right? So I think it's going to be challenging, right, depending on which jurisdiction you're in and which law is being alleged. The other thing that I would look to in an investigation is to see if there were, and maybe not in particularly with Sam, but with Charlene, is to look to see if there was other evidence of discrimination, right? Because that's what you're going to need under Title VII. If she can show that other chiefs, not necessarily a chief of, I forgot her title already, but CDO, right? But there are other male chiefs that were paid above the market, but she was paid below. And there was other anecdotal evidence of discriminatory behavior. There has been at least one case that has held that is sufficient evidence to show discrimination under Title VII.
Yeah, and I would just add from my standpoint, I think one thing we've seen commonly in cases in the last several years, particularly in the tech industry, is the tendency for companies, especially when they've been startups and they've grown very rapidly into large organizations, they call everybody a software engineer. And so, that may have started out as an accurate description, but things evolve over time and people get more specialized, the work becomes more specialized as companies grow and offer new products and services. So I think particularly for the SEALs in this hypothetical, it would be, if available, interesting to understand a little bit more about, as Kate was saying, what are the projects they're working on? Are there specialized skill sets required for particular individuals' work that they're doing? And are those job related and reasonable? Or is it a case where, someone has a specialized skill set, we don't really need it, but we're gonna pay them a lot of extra because we really want this amazing hotshot software engineer within the industry. So I think really looking into what are the responsibilities that these individuals have, and what are their skill sets that they're bringing to bear on those is critical.
So we talked a little bit about Sam's comparators, and Joy, you started talking about Sherilyn. So I guess we can move to her as the chief development officer, and what the particular challenges would be in bringing a case for her. And I don't know, an evaluation maybe, is this a stronger case or weaker case than the one we just looked at for Sam?
Yeah, so Charlene is a little trickier in some aspects because she is the only one with her job title. So arguably, she's a super special snowflake that can't be underpaid, right? Because she doesn't have any comparators. But I would encourage her to look at Al and the other people in that C-suite and look at who they report to, kind of what that reporting structure looks like, how many direct reports, how many people are there managing, what are their day-to-day management responsibilities? Because often at that level, that is more indicative of the jobs that people are actually doing on a day-to-day basis than the jobs that the people who report to them are doing. So I would encourage them to look at those things. I think a lot of people at this level also will look at predecessors and maybe successors in the position as indicative of whether they're being underpaid on the basis of gender or another factor. Also, they often will have a line of sight into what their subordinates are getting paid. And so I've had many clients say, I am reporting or I'm managing these people, and there are men below me with substantially less experience and fewer qualifications, and they're only getting paid slightly less than me, right? So that's another factor that we might look at to be able to make the case for Charlene, who is the only person in her position, right? And so you need to get creative and kind of think about those things in trying to establish her comparators.
And I would look at the same things, but I would try to find distinctions, right, between what Sherilyn's doing, what the other chiefs are doing. I would definitely, as I mentioned before, look to see if there was other evidence of discrimination against women in this particular case. Again, because of the risk that there's a Title VII case, not an Equal Pay Act case. So that's what I would look at as well.
Yeah, same for me. Looking at the same things. What are they doing, and what is Charlene doing in comparison to other chief officers?
So I think this raises another interesting question. So if we think about these comparator groups that we were just talking about, would it be any different, or would it be the same kind of analysis if we're thinking about being proactive and trying to fix this in terms of undertaking a study?
Yeah, I'm interested to hear what Katie has to say. Sam, this is someone who does those kind of studies.
Yeah, so I think it's a really interesting question. I wouldn't say that anything we do or would want to do is different depending on whether it's proactive or litigation-based or working with plaintiffs or defense counsel. Ultimately, the goal and arguably the most critical part from my standpoint is understanding those job groupings and making sure those are accurate in terms of being substantially similar in terms of those key characteristics. I think the difference comes into play more so in the type of information that you have available working in those different scenarios. So if you're doing a proactive audit, or even are working on a defense side case, you have access to the organization itself, right? So there's a little bit more opportunity, or a lot more opportunity, to really dive in to the different types of work being done. So this could look like interviewing some subject matter experts within the organization to understand that work. What are the key activities of the role? What are the key tasks that folks do to accomplish their role, and what are the knowledge, skills, and abilities that they need to be able to accomplish those activities and goals. So being able to really dive into that a little bit further, and also you could conduct some focus groups with those same subject matter experts or similar subject matter experts to really refine and understand what those job groupings are. the best way to do that would be through a thorough job analysis. That's not always feasible, but doing some sort of deeper dive into the work is really critical to understanding those job groupings. If you're working with plaintiffs, obviously you're on the outside of the organization, so you don't have access to that much information and have to rely a little bit more on what the company has produced in terms of their organizational structure. Do they have job functions, job families within those functions? You know, how does their work align according to their standards and their documentation? Do they have sort of consistent job levels across the organization? And those are often the sort of most information you can get to understand what those groupings look like. So it's not really the approach that changes, but more the information that you have available, I think, changes.
I actually have a slightly different perspective, which I think is interesting, though. Because from my perspective, I think ideally the employer should be conducting a proactive analysis based on their pay structure, on how they pay their employees, right? As opposed to thinking ahead, right? Because the whole purpose of a proactive analysis, right, is to identify where you have problems, right? Not all pay differences are a problem, right? It is only the ones that you can't explain. And if this is how you're going to defend your pay structure, that is how you should structure your analysis, right? But in litigation, as I said, I would start with, let's analyze the claims that are being put forth. Let's look at who the plaintiffs' counsel is grouping together. But hopefully, if you've done a proactive pay analysis, you will already be aware, right, and of how you are going to defend your pay. And so that's the way that I usually look at it, right, with a client that's going to do a proactive analysis. And they have to do their homework first, right? You can't just, I'm sure you've seen it too, Katie, right? You have to actually look at your pay structure and have a pay structure in place. I've worked with clients that have started down the path of doing a proactive analysis only for them to find out, well, we're redoing our whole job group, right? Our job grades and our job structure, to which, my recommendation is, well, then why don't we just wait, right? Until you have that structure in place.
Right.
Because otherwise you're gonna identify flags that may not truly be flags, right? Because you're comparing apples with oranges.
Yeah, and I think I guess the work that I was discussing is kind of that homework, right? If you had an ideal world and you could say, all right, what should our groupings be? That's sort of the path we would take. I think another, I guess, to follow up on what you were saying, Joy, we've had, some situations where you go into an organization and they have, just making this up, but they have 1,000 employees and they have 900 job titles. And so what do you do with that information, and how do you go about figuring out how to analyze it? You might start even without considering those job groupings. Just let's look at males versus females in this organization as a whole. Do we have any pay discrepancy there at that really big EEO grouping level? And then you can kind of start to try to dive in deeper and make those groupings. But yeah, agree. It's kind of a balance, right?
I love this, and I think once the employer gets to the point where they're beyond kind of that initial investigation and gets to the point where they are looking at an analysis that they think is meaningful, I would want to see that in litigation, and I think an employer would have a hard time saying the analysis and the groupings that we used to do this assessment that we found meaningful are not important for the court to look at for purposes of the claims. I think that's great.
Right. Again, I wouldn't rely necessarily on hopefully a privileged proactive analysis initially, right? But I think that it helps employers develop a defense, right? To determine and identify whether there truly are problematic differences in pay, or whether it's just a matter of the groupings that are being alleged. So I totally agree with you on that. But the question that I always have, and because I've seen it too. I've seen enforcement agencies, not Kate's firm, but other plaintiffs' firms, that try to group together, right, a large number of employees. And I'm not a statistician. I don't play one on TV either. But my understanding is that the larger data sets that you have, right, it's going to trigger a finding, a statistical finding. And so then the job or the hard work then is trying to like pare down that grouping. But my question, and actually I've had clients ask this too, because at what point do you stop the analysis? When do you keep doing the groupings? Do you just keep regrouping employees until you find an answer that you like? Which, my advice is no. I think you should do it the way that you really truly pay. But at what point do you stop, whether it's proactive or in litigation? And maybe that's a question for Katie.
Yeah, I mean, I think it's when you feel comfortable with those job groupings that you have. And so that might be your first shot at the groupings. It might not be what the organization likes. It might not be the results that they want to see, but if that's how, if they have job functions and job levels and they have clearly explained information in such a way that those groupings are clear, then I think it's really hard to say there's more information here without doing that deeper dive into the jobs to see, is there really a difference? So if we've got, 5,000 software engineers, maybe we can dive deeper into that and see how those jobs should be grouped. But I think for me, it all comes back to those job groupings. And I think relatedly, with the groupings, you run into sample size issues. So if you, as Joy was saying, if you have a huge data set, you're just more likely to find statistical significance, regardless of whether the effect is there or not. But the other side of it is if you have too small of groupings, then you're much more limited in what you can analyze and how you can sort of examine the different potential explanatory factors. So the sample size shouldn't drive any sort of decision-making around the groupings, but it is an outcome of those groupings in terms of what you're able to explore.
Okay, so I'm going to shift gears a little bit back to litigation.
There's a question.
Oh, a question.
Yes, one
Yeah.
I understand your analysis, what you're saying, but aren't there other factors? For example, particularly in a group as large as this one, we're talking the hypothetical, wouldn't you want also to look at potential differences in prior experience or qualifications of incumbents? Clearly, you may have people with 10 years of experience, you may have people with 1 year of experience, you may have people with different degrees. All those, one would think, are relevant to determining appropriate salaries, particularly within a wide range.
Absolutely.
Yep.
I absolutely agree that all of those are legitimate, non-discriminatory business factors that impact pay, right, that would go into the types of analysis that are being done. I don't know, arguably, whether that would impact, right, who are comparator groups, right, for litigation, right? So I think there's different factors that you look at for the analysis, and perhaps, but go ahead.
Yeah, I think if that is a factor that the company uses in setting pay, I think it would be a control in the analysis, not necessarily a separate regression for each one. And I think that also gets to the point of what else should you look at? Should you look at performance? If the company pays on that basis, then yes, you should look at performance. On the other hand, I'm going to want to look at what the effect of that is and whether I can make the case that the performance ratings themselves are discriminatory, and those are tainted variables and should therefore not be included.
Totally agree. And often we find performance ratings within companies aren't very differentiated either. So you don't have enough variability to really find much of an effect from performance ratings. But totally agree, those are all really great explanatory factors that an organization should look at when trying to figure out why are folks paid differently if they are.
Some of the issues, though, with those factors, I'm sure you've seen it, you've both seen it, is whether the employers actually documented or kept those records. We used, the software or the tech industry here, but you see it in all industries with professors, right? I've seen explanations for differences in pay that have to do with publication, right? The field of study that they're teaching in sales, you know, the types of products that are being sold, the market, and some of that information is challenging to pull if the employer has it at all.
Yeah, and we're seeing, at least at my firm, improvement in data retention and data capturing. I do think, though, it still can be a huge challenge. You know, you might have a client who said, well, we implemented this HRIS 2 years ago, so we have data for 2 years, but nothing before that, or nothing captured from anyone who was hired before 2 years ago. So having the data on that type of information can definitely be a challenge.
All right, so now I'm going to switch gears into discovery and litigation strategies and discovery limits. So one of the questions I think would be, you know, what if X contends that its pay equity analysis showed no statistically significant unexplained differences based on sex?
I think I'm going to want to ask a couple questions there. Well, first, I'm going to want to see it. If they're going to rely on it, I need to be able to take a look at it. And then I'm going to look at whether the aggregations or disaggregations were appropriate, if they're actually excluding from their comparator groupings people that should be grouped together, if they're getting too small of groups such that it will be hard to find statistical significance no matter what's happening. And then I'm also going to look at those tainted variables that we touched on. But I
Yes,
think- yeah.
I would not lead with a privileged analysis, as I said. I would start by looking at the claims and analyzing the claims first and analyzing that group of information. I think here, whether that analysis that was done is arguably, I don't even think it's privileged, right? Because, you know, just merely copying, whether it's internal or external counsel on an email with the results, or having them present in the room while you're discussing the results, I think it's arguable that this analysis and the hypothetical is privileged. But there may be times, right, that an employer wants and should rely on a proactive analysis, in which case, you know, I think that they certainly should. Right, the underlying data that's used in that analysis is never going to be privileged, it's just the results. But the more that you want to rely on it, you're going to have to waive the privilege.
So I guess another question would come up in this question of what substantially similar work would be in the problem, and how much discovery would be allowed. Would Sam or Charlene be able to get discovery on projects that other employees are working on, or what tasks they're assigned?
I think, so first, if we have a class case, then often you're able to get very broad discovery that is centrally located. And there I'm going to really want to be looking only at what is in the data. I think here we're talking about individual comparators and can we get discovery into what those specific individuals were doing. I think the strongest argument is always if things are centrally located, right? The burden is low. So I'm going to want to look at those sources of data, if they're in performance reviews, if I can get it through 1 or 2 manager depositions, if there's time records or project lists. I'm going to want to look at the easiest way I can get it to figure out how the kind of work that people are doing, if in fact that work is determinative or a factor that the company uses in setting pay.
Yes, and hopefully, you know, that the employer's attorneys have done their due diligence and done an investigation. If it's going to help their defense, I probably would not have a problem turning it over. Whether it's centrally located data, I think that's pretty much fallacy. I don't know what your experience has been, Katie, but I will tell you that very few employers have a central database. Y'all remember the EEO-1 Component 2 reporting requirements where certain employers had to report wages, compensation, and then hours worked? I can't tell you how many employers keep that hours worked information in a separate system than their compensation, and that goes the same for like performance ratings. I would say very few actually track experience, because you'd have to track, right, their resumes. So it does take time, right, for an employer to pull all of that requested information. And then as an employer-side attorney, I would never turn over any information unless you've analyzed it first. And look, regardless of what you find, you either need to be able to defend, right, statistically significant differences, or you need to be comfortable with that the information you're turning over refutes any claim of discrimination. Because once that toothpaste is out of that tube, you can't get it back in. So I wouldn't turn over anything unless I looked at it first.
What about discovery on performance and bonus payments, evaluations?
Yeah, I mean, I think that is, 5 minutes, okay. I think that is directly relevant to pay. My understanding is that that would be in a single place, that you wouldn't have to go out to all the offices and ask everyone, although maybe Joy is going to tell me about headaches she's had in collecting stuff. But yes, salary and bonus information and performance related to that, if it's something that the company considers in setting pay, then I'm going to want to take a look at it.
Right, I agree. If bonus is part of the compensation package that's being challenged, then I don't know how you could not turn that over. I agree with you about performance ratings. I will say that many times I have seen that performance ratings are not truly reflective of performance or the increases that are being given. I can tell you of a number of times where I have reviewed performance evaluations and seen, oh, all the ratings, everybody's a 3. But like, look at, if you read the narratives are quite different, right? And then, so, or vice versa, like, oh, somebody's like a 10, and oh, this person's a 3, but the narratives are exactly the same. Now, I think a large time that's probably, the difficulty of your acting supervisors that are just like, it's evaluation time, I'm gonna cut and paste, but it creates a problem, right? But I'm sure that Katie have seen that when you're doing correlations, right,
Yeah.
with respect to performance ratings and pay.
Yeah, performance ratings are very challenging, at least those collected from the organization, because of all of these issues. So often there's no variance or little variance that can be leveraged. Similarly, we do see manager comments that, like Joy is saying, reflect no major issues with a particular employee, but when it comes time for layoffs, they've got, a big performance issue that we don't see in the evidence behind it. So, but yes, I do see typically like the salary, the bonus information, all of that housed together. Performance ratings often will get as sort of a separate download, which we can put those together, of course, but much beyond that, especially the experience, which you would really want to have to really truly analyze, what's happening, that's really hard to get for all of the reasons we've discussed.
Okay, so now is the time when we can maybe have a couple minutes here, not much, but maybe just to take some quick questions. And if people just want to ask their question, and I can gather them together for the panel, and then everyone will get a final word. Yes, over here.
Marcia Adams from the National Labor Relations Board, Region 29. Excuse my voice. My question is, it seems to me that the professionals who have the most knowledge and education and about this whole process are the HR professionals. Are they being so well trained and informed and educated to help the companies that they work for in-house to alleviate and prevent some of these issues? What if you all know of what is being done on the undergrad and the graduate level in human resources administration?
Okay, great question on HR. Do we have any other questions? Just gathering maybe one more, 2 more questions. Over here? Yeah.
Hi, Greg Revere, actually in HR, so.
Oh, great.
From Forster, New Jersey. So my question, I mean, and I've seen a lot of issues with like the application of this, and we recently did revamp all of these categories that were mentioned earlier, like internally. One of the questions I had is, I've been hearing a lot about the trend of like skills-based management, and that's kind of like trendy now, and like labeling jobs and labeling applicants by their skills. And sometimes applicants like self-identifying their skills in their application. I'd like to hear some comments about how that level of granularity from from internal applications, right? So on and so forth, the manager evaluation of that candidate and what pay they're determining. They might say, well, you applied identifying with this exceptional skill, but you're not using that in this job. You're not really like using that's not really at play. They might discard that, you know, and bias can kind of seep in that evaluation of skills. What do you see on the ground with like the applicant side and then the management side of evaluating skills of the incumbent and the actual job, because those are two different things.
Okay, and then Sam, you had your hand up? Oh, okay.
Mine's a very good question. I don't understand, what's the position on performance ratings? I mean, if the company is making pay determinations on performance, even if there is bias or subjectivity, how can you disregard it? That's how they're making their decision. I mean, it might be another occasion to challenge excessive subjectivity and that sort of thing. But I don't see how you can make that a major control in your analysis. I guess this is for the quantitative aspect.
All right, each of you is going to get 1 minute to reply to all of these great questions from the audience, and thank you very much for the questions. Kate?
Sure, I'll go very quickly because I am interested in what my colleagues have to say on this. I'll touch on the skills-based component because I do think that can get tricky, and a lot of the regulations around particularly the Equal Pay Act say look at what the employer is evaluating and what the jobs actually require. So that would counsel in favor of doing kind of less what the employee says the skills that they bring to bear are, but more what the job is requiring. But Joy, I don't know if you have more to say on that.
All right, so I'll go, right? So I agree that you have to use the performance reviews, right? That's all right. I think the question was how do you not include performance ratings, right, in an analysis of pay? And the answer is you can't exclude it, right? If the employer is saying that performance is a factor that impacts pay, you have to analyze it. What will happen, well, I'll let Katie explain what will happen. I'll let her do that in her minute. In terms of the two questions about what HR managers are doing, I think that is the challenge. That is a challenge, right? That is the challenge piece of this theme, right? Is that there's still a lot of subjectivity, right, that managers are given in terms of evaluating skills, even if it's a skills-based metric. I totally agree. I've seen that a lot where, oh, this person has some unique skills. We don't have that yet. We brought them in at a higher rate, right? And so it's now going to skew the data. So I've challenged with that. The challenge with HR managers is that there's a tension between HR and recruiting, right? Because recruiters they're trying to fill openings. They're getting pressures from managers, right, to find the best talent. And so HR is trying to control, right, and the comp teams are trying to control what's being paid, but then you see recruiters like, oh, we can get this person if we just throw them a little bit more money. So there is a tension. I think it's going to take a lot of education, right, between HR and recruiters and the hiring managers.
Yep, and just real quick, the performance ratings, totally agree. You do have to include them. It's just that they might not impact the results very much because there's not much variability in them. Yeah.
All performance evaluations are uniform?
Not all, but.
Only when times are good.
Right.
And it's not, yeah, there's there's a lot of reasons for that, right? People who aren't performing well often are moved out of the organization. So, and then the only other thing I would just say in terms of HR is something else we also look at is when a company has particular policies and procedures that are in place, that's one thing, but then how are they being executed and are they being followed consistently? So kind of to your point, if, is the training there and then is it being actually implemented effectively within the organization?
So we're wrapping up here. We have on the slides just some case law additional resources for you to look at. And thank you so much.
Thank you.